This is the appointed time. We have a quorum, so let's give a start. Let's invite the administration in. Mr. Raymond Wong, we have done with the roll call. I have announced that the meeting, or I have called the meeting to order. So let's follow up with the issues raised at the last meeting. Let's give a start when the administration has come in. Now, on the 22nd of December 2014, members raised various issues at that meeting, and the administration has given a response. The paper is CB bracket 1423/1415 bracket 02, which has been circulated to members. So should I invite Permanent Secretary to walk us through the paper? Thank you, Chairman. This paper responses to issues arising at the last meeting. The first point is about the power of the Independent Insurance Authority, IIA, to accept gifts. And I reiterate that other relevant bodies also have this power. And members' views were that when gifts are accepted, provisions should be made in the Prevention of Bribery Ordinance, and we have proposed a consequential amendment in the sense that the IIA will be specified as a public body under the Prevention of Bribery Ordinance, such that any member or employee of IIA will be regarded as a public servant for the purposes of the PBO, and they'll be subject to the regulation under this ordinance. That means they must not accept or solicit any advantage which may contravene the PBO. So by specifying IIA as a public body under the PBO, we believe that the purpose can be served, and therefore there is no need to expressly provide for the IIA to comply with the PBO. And also on the engagement of consultants, agents, and advisors, last time it was said that for other regulatory bodies they engage consultants and agents, and there was a question on the fees involved, and according to our understanding, there is a breakdown in the expenditure setting out professional service fees, as explained in the paper. For SFC, for the last financial year, the total expense on legal and professional fees was $57.56 million. For the Office of the Commissioner of Insurance, which has commissioned a consultancy study on risk-based capital framework for insurance business in Hong Kong, the fees were $5.6 million. So, if necessary, we are going to report to members on any amendments, and also at the committee stage, we will propose amendments. So much from me, and I welcome questions from members. Who would like to ask questions? Mr. Liu Xinwing. Thank you, Chairman. On expenditure for the actual needs and in a reasonable manner, these two are just principles. They're not concrete figures. If the administration is actually acting in accordance with its actual needs in deploying manpower and engaging professionals, I don't think this is a major operational issue. On the contrary, it will remind the future regulatory body to act in accordance with its actual needs and in a reasonable manner. If the administration is not minded to amend this part, I have reservations over this. I'm sorry, by having reservations, you mean you are going to put this on record, or you're going to propose amendment? I want to put my view on record. Any other comments on professional fees or remuneration? Mr. Shankin Paul. For engaging consultants and advisors, I don't think it's absolutely necessary. If it is, then I don't have much to say. For example, for the risk-based capital framework, some $5.6 million were spent. Well, comparing to SFC, I don't think the IIA will be spending this much unless it has it has investigation work to do. Well, at this stage, I don't have any particular comment. All right, if there are no questions, let's move on to the next part. Clause by clause examination. We'll begin from clause 14, which is page 23 of the marked up copy. There aren't any new problem in page 23. But the whole section, section 5, will be deleted. Yes, on page 23 of the marked up copy, section 5 has to do with register of insurers, and we propose to delete this section because the new 5H will replace this section. We will read it out when we come to that in a moment. If there are no questions, then on page 24. Which is Division 2, Accounting and Financial Arrangements. 5A contains interpretation of auditor and financial year. 5B is the corporate plan and annual estimates of the IIA. The financial year of the authority begins on the 1st of April in each year. And the first financial year of the authority will begin on the commencement date of Section 15 of the Bill and end on the following 31st of March. 5B3. The authority must, no later than 31st of December in each financial year, submit to the Financial Secretary for approval a corporate plan for the next financial year. A corporate plan must specify the objectives for the authority's activities for that year, the nature and scope of the activities to be undertaken, and the estimates of the authority's income and expenditure for that year. And then subsection 5, the Financial Secretary must lay a copy of the estimates specified in the corporate plan as approved under subsection 3 on the table of LegCo. Any questions? No? Please go on. 5C, appropriation. Now, our proposal is that the IIA should be independent of the government, and its operation is sustained by the revenue generated. And here it says that for each financial year the government must pay to the authority out of the general revenue the monies appropriated by the Legislative Council for that purpose. Yes, a very short question. For the SFC, the wording is different in Chinese. It says for each financial year the government must pay the SFC out of the general revenue, the money, so on, so and so forth. Now the wording is a bit different. My question is, why don't you just copy it exactly from the SFC version? Yes, why don't you copy it? Is there a problem with SFC? Thank you, Mrs. Sin, for your question. Mr. Sin is referring to 5 capital C, right? Well, when we prepared this Insurance Companies Amendment Bill 2014, we considered the new wording an improvement. There is nothing wrong with the provision in the SFC ordinance. Yes, but my question is, if there is nothing wrong with the SFO, why don't you just copy the provision? Why aren't the two ordinances different? Let me read it out. In fact, for 5C, that is Section 14 of the SFO, for each financial year, the government must pay to the authority out of the general revenue and monies appropriated by electrical in that financial year for that purpose. So it seems the meaning's the same. If it is the same, why don't you copy from SFO? I need to refer to the details and the English text of the SFO to see if it is consistent first, because in drafting we need to consider both the Chinese and English version. Now, if the English version is not the same, I can understand why you change the Chinese version, because we're scrutinizing the bill clause by clause. Yes, please note that and follow up on it. If the English version of the Securities and Futures Ordinance is the same as this section in the bill, then we would like to see some consistency in the Chinese version as well. Please continue. 5 capital D, Accounts and Annual Report. The authority must keep proper accounts and records of its transactions, and the authority must, as soon as practicable after the end of each financial year, prepare financial statements. And the financial statements should give a true and fair view of the cash flow and the state of affairs of the authority, and it should be signed by the chairperson and the CEO of the authority. And after the end of each financial year, the authority must, as soon as practicable, prepare a report about its activities and send a copy of the report to the financial secretary, and the financial secretary must lay a copy of the above said report on the table of the electrical. Mr. Chan Kim-po. Thank you, Chairman. Now, there is concern from the insurance industry that with increase in manpower of the IIA by almost double, to regulate intermediaries as well. In this annual report, it only says that the report will be tabled in electrical, but there is no way the electrical could veto the report. Electrical could only note that report. So how can you address the concern that the authority will not expand too rapidly, such that the cost will spiral to an extent more than necessary, because you don't have any control over its activities. So is there a mechanism so that in future there can be some sort of control over improper expansion by the electrical?
In fact, this matter has been discussed before, Chairman. We said that we would make reference to how the SFC budget was dealt with. In other words, the FA panel will be consulted before the budget goes to the Financial Secretary. And if we look at similar regulatory bodies, now we can see that in fact the SFC has an establishment of about 750 people, HKMA about 800, MPFA about 600. And for the IIA, we believe the establishment should be at around 250. So you can see that the establishment is going to be streamlined. And then at the moment we have 150 people at the ICO. And the establishment will only increase by about 100, even if the authority has to take on the responsibility of the licensing of the intermediaries. So in fact, we're exercising a lot of restraint. So members should feel assured. In fact, we do understand that different regulatory bodies carry out different regulatory work, and I think the establishment of the body should be commensurate with the complexity of the regulatory work it carries out. Now, concerning HKM, SFC and the MPFA. Now they have become big monsters that that even the FSTB cannot control. In fact, no one can say whether the establishment of these regulatory bodies is too excessive. Now, for the IIA, of course, the proposed establishment is still rather modest. But then, you know, these regulatory bodies are like independent kingdoms, and their establishment may continue to expand. No one can control them. That's the problem. And then, is it really useful to just give a report to the FA panel? Now, I want to say that this is a meeting of the Bills Committee. We're looking at the proposed establishment of the IIA, and so we are concerned about the establishment of other regulatory bodies like the SFC. I think you should follow up in the FA panel. All right, Chairman. So back to my original question. I think it's not enough to just have a discussion in the FA panel with regard to the budget of the IIA. Now, there will be an amendment or a CSA to include the IIA as an organization that can be audited by the Director of Audit, and as a result, value for money studies can be carried out by the Director of Audit. Are you satisfied, Mr. Chan? Yes, but then of course I'm concerned about this is a very bigger issue. All right, thank you, Chairman. Page 26. 5 capital E auditors. The authority must, with the approval of the Financial Secretary, appoint one or more auditors. An auditor has a right of access at all reasonable times to the books, accounts, vouchers, records, and documents kept by the authority, and is entitled to require from the officers of the authority the information and explanations that the auditor considers necessary for the discharge of the auditor's duties. The Director of Audit or another public officer authorized by the Director for the purpose may, at any reasonable time, examine any books, accounts, vouchers, records, or documents kept by the authority, and if the Director or the public officer considers it appropriate, make a copy of the whole of or any entry in those books, accounts, vouchers, records, or documents. If members have no questions, then we can move on to 5 capital F, financial statements to be audited. The authority must, as soon as practicable after the end of each financial year, provide an auditor for audit with the financial statements prepared for the year under Section 5D. The auditor must prepare a report on those financial statements and send the report to the authority. The report must include a statement as to whether, in the opinion of the auditor, the financial statements give a true and fair view of the state of affairs of the authority as at the end of the financial year and the results of the operations and cash flows of the authority in that year. The authority must, as soon as practicable after receiving the report, provide the FS with a copy of the report and of the related financial statements, and the Financial Secretary must lay a copy of the report and of the financial or related financial statements on the table of the LegCo. No questions? Please continue. 5G, tax exemption. The authority is exempt from taxation under the Inland Revenue Ordinance. Can I ask whether the HKMA and the MPFA and the Airport Authority are exempt from taxation under the IRO? I understand that the SFC is. Chairman, as to whether all other public bodies are exempt from taxation, I don't have the information, but then all the regulatory bodies are exempt from taxation. Mr. Chen. No, in fact, why do we have to put in this section on tax exemption? Because it's hard to imagine how the IIA can make a profit. I think it's a matter of principle, Chairman. The IIA is going to be a public body exercising certain public functions, and the IIA is bound to receive some income. And if a member of the public wants to obtain a copy of the register of insurance companies or the register of licensed intermediaries, then a fee will have to be paid, and so the authority will get some income, and as a result it may have a profit. But then this is stated very clearly that the authority is exempt from taxation. All right, in the case that the authority has a profit, it is exempt from taxation. And I want to say that 70% of the income of the authority will come from levies, and about 30% will come from license fees collected from insurance companies and intermediaries. And when the operating reserve of the authority reaches a certain level, then it has to propose a reduction in the levy. But then in theory, the authority will not be able to make great profits. In fact, our objective is to achieve a break-even situation. Right? Any other follow-up questions? No? Please continue. 5H. In fact, that's the part deleted on page 23. So we are now on 63 and also clause 68. And page 28, Chairman. In fact, this is 5H, Register of Authorized Insurers. 5H bracket 1A to E are in fact existing provisions. F is new. And that is if the authorization of an authorized insurer is suspended under section 41P to B, then the authority must keep a note to that effect. And in fact, this relates to the taking of disciplinary action. And then 5H2, A and B, and also 3, 4, and 5 relate to the register. The register has to be made available for public inspection. Right? Any questions? Or no? Please continue then. Thank you, Chairman. Page 30. 6, 7, 8, and 10. We are updating the terms. In fact, from the insurance authority to the authority, and then so we have the updating of the these various references. Right, please continue. Page 38, Chairman. Section 11. Aid 2 relates to appeal against refusal of authorization. So, where the authority thinks that the person concerned is not a fit and proper person, then a decision to refuse may be made, and then an appeal can be made. So you can see that we've deleted certain parts under 2 and 4. Because there is this mechanism at the moment for an appeal to the FS. And in future, such appeals will be dealt with by the appeals tribunal. So the appeal channel or mechanism will be detailed in another section later in the ordinance. Yes, 12, section 12. Conditions imposed under section 8 may be revoked. The authority may, by serving a notice in writing on the authorized insurer concerned, amend or revoke a condition or impose a new condition that is reasonable in the circumstances. So, this is an amended version of section 12.1. And then 12.3. If a condition referred to in subsection 1 is amended or revoked, or a new condition is imposed, the authority may direct that the register kept under section 5H be amended accordingly. And then page 39, section 13. Fee payable upon authorization and annually thereafter. So the insurance authority should read authority. So for section or subsection 2, we will add deemed under section 61(1) of the pre-amended ordinance having continued in fact the operation of section 2.7 of schedule 11. The schedule will contain some transitional arrangements. This is a technical amendment, Chairman. All right. Section 13A, 13 capital A. The present section 30 capital A says that so an authorized insurer must not appoint a person as a controller except under certain conditions. But then 13A makes similar arrangements.
That is, the authority may approve the appointment of the individual as a controller of the insurer. If there are no questions, we can move on to page 40. We've added some procedures in relation to the approval of certain controllers of authorized insurers by the authority. For example, subsection 4, the authority must not approve the appointment of an individual as a controller of the authorized insurer unless it is satisfied that the individual is a fit and proper person to be so appointed. We're on page 40. And in subsection 7, we have added that the authority may, by serving notice in writing on an authorized insurer or an individual, revoke the approval of the appointment of the individual as a controller of the insurer if it appears to the authority that he is no longer a fit and proper person so appointed. And subsection 9 sets out the procedure for revoking the appointment. That is to say, there must be written notice, and the individual may also make written representations to the authority. Yes, this is just in Shanghai. Here, subsection 9, when the appointment is to be revoked, is there any binding effect? I'm sorry, 9b, that the insurer or the individual may, within 1 month after the date of service of the preliminary notice, make written representations to the authority. Does it mean appeal? My understanding of your question is, if it is revoked, will it take effect immediately? But here, it says, within a month, the individual or the insurer, which is the subject of the revocation, can make written representations. So within that month, well, can you please explain the policy? Chairman, here it says that the insurer and the senior staff with certain responsibilities must be fit and proper person. If the authority reasonably suspects that the individual or the insurer is not a fit and proper person, then a preliminary notice will be served, and after that, in a month's time after the notice is served, the insurer can make written representations. That is to raise questions or to make objection. The serving of the preliminary notice does not mean that the individual can no longer be a responsible person of the insurance company. In the preliminary notice, the authority will specify when the decision is to take effect. And in our proposed amendments, you will see that when the authority makes certain decision, in the event that no specified commencement date is made, then according to there will be a provision on when it will take effect. So in short, it will specify when the decision is to take effect. Well, let me ask more specifically. For 9b, it says service of the notice and also service of the preliminary notice, because in subsection 9, before serving the notice under subsection 7, the authority must serve on the authorized insurer and the individual a preliminary written notice. So there is something else called the preliminary written notice. And in B, it says preliminary notice. So does it mean that there are two different things? One is a notice, the other is a preliminary written notice. If so, that means before you serve the notice, you must first serve the preliminary notice first. Chairman, yes, there is a preliminary notice. If it is served, then in a month's time, on serving the preliminary notice, the insurer can make written representations. Well, after reading subsection 9, my understanding is this: before serving the notice, the authority should first serve a preliminary notice, and once the preliminary notice is served, the authorized insurer or the individual may, within a month after that, make representations. And after reading representations, the authority can serve the notice, and only after reading the written representations. My understanding is that after serving the preliminary notice, there is still a month's time for the individual to make representations. After that month, the notice will take effect. After serving the preliminary notice, and until the notice is served, according to the common law and according to my understanding, the individual or the authorized insurer is still responsible to perform his or her duties. So it is still legally binding. Chairman, after serving the preliminary notice, within that month after the date of service of the notice, the authority's decision that the person is not a fit and proper person still hasn't taken any effect yet. So that means the authority cannot, by serving the preliminary notice, stop that individual or insurer from performing any duty. Chairman, let me supplement. That is true, because even when the authority makes this decision under the common law, it must first notify the insurer of the decision in question and that it is being considered at the moment, and then the insurer or the individual will be given a month's time to make representation or put up a defense. And if you read subsection 10, if representations are made, the authority must take them into consideration before serving a notice. So this is due process for the insurer in question to put up a defense. And even if a notice is served, a date will be specified telling the insurer that starting from a certain date, he can no longer be a controller. So before that date, the insurer could still act in the capacity of a controller. So my question is this. This is a reasonable consumption. In order to revoke the appointment of an insurer as a controller because of improper conduct or misconduct, even if the preliminary notice is served, before the final notice is served, that insurer may act even more improperly. And in that case, how can you stop this from happening? Well, let me supplement, Chairman. This is the procedure, and Mr. Sin's concern is that before the individual leaves his post, can he do whatever he wants? That is not possible, because apart from the controller, there is also a board of directors in an insurance company, and the board will also be responsible. So the board also has a duty to oversee the operation of the insurance company. So for improper conduct, as mentioned by Mr. Sin, the individual will be stopped by the board, and we have checks and balances hence. And for the insurance companies, there may be other controllers in terms of the financial position and risk management. They have controllers, other controllers. So in a insurance company itself, there are also checks and balances. And if the authority has suspicion over the appointment of an individual as a controller, and that the authority is closely monitoring that authorized insurer, and if problems are found, then the authority can interfere or can intervene through other means. For example, there may be measures to intervene the conduct of the business of that insurer. So it depends on the reason why the appointment of that individual should be revoked. And before this individual leaves his post, the authority will be looking closely into the financial position and the cash flow of the insurance company. So both outside and inside insurance companies, there are checks and balances. As I understand, we can only impose administrative penalty on the controller for its improper conduct. As for unlawful act, this would be criminal, of course, and the procedure will be expedited, or there could be other follow-up actions. If the authority notices any improper conduct on the part of the controller, or responding to Mr. Sin's concern, my explanation is that the authority has other intervening measures, and the insurance company also has other positions, such as the board of directors and other controllers that oversee the situation. So there are checks and balances. Any questions? If not, let's move on. Page 41, subsection 11. Chairman, I have another question. 11. And we're on subsection 10 only. She's on subsection 10 only. We haven't reached subsection 11. Yes, now we're on 11. An authorized insurer which contravenes subsection 1 or 8 commits an offense and is liable to a fine of $200,000. And the level of fine is the same as that in the original ordinance, subsection 9 on the left. Here, the fine is imposed on the individual, not the insurer. For the person appointed, no penalty. It's in the following, 13 AB on page 42. Just let her continue. Subsection 12 explains the meaning of the controller in this section. That is either the managing director or chief executive of the insurer, or in relation to an authorized insurer incorporated outside Hong Kong, means an individual who is the managing director of the insurer by virtue of 9(3)(a) or chief executive by virtue of 9(3)(b). And in the original ordinance, there is a provision specifying the appeal mechanism to the Finance Committee. And in future, this will be dealt with by the Insurance Appeals Tribunal, IAT, and there will be provisions on that. Chairman, this may be a very simple question. Managing director. We have managing directors and NEDs in a company. I'm reading the Chinese version. Well, in English version, the term is managing director. For non-executive director, it's in 13 AC, page 43. Yes, please allow the administration to continue.
A 大 B 啦，咁就係頭先講。
Page 42, 13 AB. So for the controller, we're talking about here a fine of $200,000 and an imprisonment for 2 years. In the case of a continuing offense, a further fine of $2,000 for each day during which the offense continues. So in fact, no change has been made to these provisions. Why is it that for the individual, there is a further fine of $2,000 for each day during which the offense continues, while for the company, there is no such penalty? Chairman. In fact, we haven't proposed any changes to the existing provisions. Perhaps we can go back and study the legislative intent, and then we will explain to members next time why there is this discrepancy. Now, of course, I have no objection to your doing the review, but then for the company, it's $200,000. For the individual, it's also $200,000. And then the individual may be imprisoned. But then for a company, you can't imprison a company. Maybe you can imprison the directors. I don't know. Because you said you would go back and take a look at this. I think the penalty is harsher on the controllers than on the companies. Now, if an authorized insurer appoints someone who shouldn't have been appointed, then is it that the insurer should be or should receive a heavier punishment? 13 AC. Yes, Chairman. Approval of directors of certain authorized insurers. In fact, Section 14 says that there can be an objection to the appointment of a director of by an authorized insurer, and here we state that the appointment of the directors have to be approved by the IIA. The arrangements are similar to those I've explained just now. Chairman, if someone is appointed as a director without the approval of the IIA, then legally speaking, is that person still a director of the insurance company? Is it that he can still claim to be a director of the insurance company? Is it that he can take certain actions on behalf of the insurance company? Chairman, authorized insurers can appoint directors only when they've obtained prior approval from the IIA. So what if a person hasn't got the approval of the IIA? What if this director hasn't got the prior approval of the IIA? Then is he still a director? In this case, the authorized insurer concerned has broken the law. And if if an authorized insurer commits this offense, the IIA can take action. But then at the same time, can that director, or is that director still a director, legally speaking? Or is it that this person, in fact, is not a director? we haven't stated here the legal consequence of a person being appointed as director without the prior approval of the IRA. But then this section states that the appointment can be made only with the prior approval of the director. Yes, that's my question, Chairman. If an insurance company still appoints someone as a director without a prior approval of the IIA, of course, this insurance company has breached the law. But then concerning this appointed person, is he still a director, legally speaking? And can he claim that he is a director of the insurance company, and can he commit any acts on behalf of the insurance company? Now, the precondition is that he cannot be a director of an insurance company without the prior approval of the IIA. So if he simply can't be a director of an insurance company without the IIA's approval, then he is of course not a director. But because we do have statutory forms for insurance companies to fill in concerning who their directors are. Now, say if I claim to be a director of an insurance company, and in fact there hasn't been any prior approval by the IA, then I'm making a false claim. Now, say for example, for a multinational insurance company. Now, I'll say under the UK law, certain people are directors of this insurance company, and they can exercise their authority or powers as directors of the insurance company. But then their appointment in Hong Kong has not been approved by the IIA. So are they still directors? Is it that the company, it's true, has breached the law, but in fact they are still directors of the insurance company, legally speaking? Chairman, under 13AC1, it says an authorized insurer which is incorporated in Hong Kong. So this is an insurance company registered in Hong Kong. So this is about the board of directors in Hong Kong, and so there must be prior approval by the IIA. But then if it is a branch of an overseas insurance company, then that's not under 13AC1. But then for the CEO, for the managing director, of course there are certain provisions here, but then I think it's important to note that 13AC1 is about an authorized insurer incorporated in Hong Kong. Mr. Sin Chung Kai. Now you have to register the directorship with the company's registry. And is it that the company's registry will refuse registration if there is no prior approval from the IIA? If it's a local insurance company, then of course it's incorporated in Hong Kong. But then for international insurance companies with a parent company in another country, then these companies may have a branch or a subsidiary in Hong Kong. If it is a subsidiary, then the company is incorporated and registered in Hong Kong, and so it has its board of directors in Hong Kong, and the directors must be approved by the IIA first. Mr. Chen Kim-po, Chairman, I wish to clarify this point. I understand that at the moment, approval is required only for the controller. So is it that in the future, approval will be required even for independent non-executive directors? For locally registered insurance companies, they need to fill in statutory forms on their directors, and we can object to a person being appointed as a director. So at the moment, you may oppose the appointment, but in future, a prior approval from the IA is required. Yes, Chairman. 13 AD. $200,000 imprisonment for 2 years, or $2,000 for each day during which the offense continues. 13 AE. This is a new subsection because of the requirement of the international association. We have this provision on key persons in control functions. So they must be approved by the IIA. And the arrangements are similar to those applied to directors. And then the definition of control functions or key persons in control functions. So in relation to an authorized insurer which is incorporated in Hong Kong means an individual who performs one or more of the control functions for the insurer, or in relation to an authorized insurer which is incorporated outside Hong Kong means an individual who performs one or more of the control functions for the insurer in respect of so much of its insurance business as is carried on within Hong Kong. And then control functions in relation to an authorized insurer means any of the following functions. A. Intermediary management functions, which in relation to an authorized insurer which carries on insurance business through licensed insurance intermediaries or accepts referral of insurance business from licensed insurance intermediaries, means a function to establish and maintain internal control measures for administering the licensed insurance agencies and licensed individual insurance agents appointed by the insurer, monitoring the compliance with this ordinance by the licensed insurance agencies and licensed individual insurance agents appointed by the insurer, and ensuring the compliance by the licensed insurance intermediaries that refer insurance business to the insurer with the conduct requirements specified in Part 11 and in any code of conduct or guideline published under Section 92 and 93. So under the core principles published by the IAIS, the functions include risk control, compliance, internal auditing, and so on and so forth. But our provision doesn't contain these functions. We've consulted the insurance sector. They have no objection to incorporating these functions. So we are now drafting the amendments, and we will provide the Bills Committee with the amendments later.
Well, can you tell us here what functions you are referring to, having communicated with the industry? Have you widened the scope? Chairman, perhaps let me supplement. We propose to add some. Now in the provision, we already include the functions of the insurance intermediary, and we plan to include these compliance officer, the audit officer, the internal audit officer. Chairman, sorry, I need to go back a bit. I can't catch up. I'm still reading AC and AE. AC, CAC, page 44, subsection 11, My understanding is that the insurer will be penalized. For AD, the individual will be penalized. So similar to A and B, is it necessary to review the level of penalty? Should the insurance company be penalized as well, and what are the justifications? Yes, we'll report to the Bills Committee next time. Yes, please note this question. For penalty imposed on the insurer and on the individual, they are of the same amount. So for individual, the penalty is heavier because there is a daily fine for individual. For the insurer, however, there is no such daily fine. So what is the legislative intent? Please tell us next time. All right, Mr. Sin? Thank you. Thank you for repeating my question. Please go on. Mr. Ho. Now, about the control functions, as I understand, we are still on 13AE, and then I see in subsections 14 and 15 of section 13AE, page 49, it says the financial secretary can publish by notice in the Gazette, specify a function to be a control function. Now you talk about 4 control functions, but here, because of subsection 14, does it mean that the financial secretary can add or reduce control functions, and will there be a mechanism for discussing with the industry, or will the financial secretary make all the decision? And in subsection 15, again, we see the power lies with the financial secretary. Can you explain to us about 15 and 14? Chairman, for the core principles of the IAIS, the International Association of Insurance Supervisors, they have included some control functions which we regard to be very important in the governance of insurance companies. And in the core principles, for financial controller, it's not set out in the IAIS requirement, but it's adopted by many jurisdictions because financial controllers are very important. So we propose to specify these control functions. We have subsections 14 and 15 here because in future, if there are changes to the core principles of the International Insurance Association, and if they want to make changes to add a control function in the light of the industry's development, these subsections will provide an expeditious means to add more control functions. For the proposed control functions, at the moment we consider them most important personnel in insurance companies, and their roles also perform checks and balances against each other. So if we include these control functions first of all, we give them higher recognition and we attach greater importance to their functions and responsibilities. So at this time, we believe that it is sufficient. So 4 functions at the moment are sufficient. And then subsection 14, the financial secretary may publish by notice in the Gazette, so on and so forth. So will it be negative vetting or positive vetting? Even if a notice is published in the Gazette, it will be in the form of subsidiary legislation, and we may have to table it in LegCo, follow the negative vetting procedure. So there'll be a chance for us to explain to LegCo our changes and to consult the industry. Chairman, I'm very concerned about negative vetting. Maybe today the administration still has sufficient consultation with the industry, so 21 plus 28 days may be sufficient. But in future, we have no idea whether you will consult the industry fully. This may not be a very important change, but I want to put it on record that I have strong views on the negative vetting procedure. Mr. Sin Chung Kai. Chairman, for key functions, well, you're going to submit CSAs, right? I think it's better if we have a schedule rather than a provision here, because if I were the insurer, and if the financial secretary specifies a cleaner as a key control function, key person in control function, then wouldn't it be strange? So it's better to have scheduled along with interpretation. I understand Ms. Ho and Mr. Sin's concerns, but in fact, on page 342 in section 143, we provide that in accordance with section section 13AE, that is, if a notice is published in the Gazette by the Financial Secretary in accordance with 13AE, the public should be consulted on the draft first. So, Ms. Ho, there is no need to worry whether changes will be made unilaterally. So, here it stipulates that a draft should be prepared first, and the public should be consulted before a notice is published in the Gazette. So, this is for your reference, Ms. Ho. This bill is very long, and frankly, I have to say that I haven't read page 342. I thank the administration for cross-referencing this point, but it just occurred to me that this is similar to the country park enclaves, because there the government announced the draft development plan, DPA, and then we tried to object, and then we were told that it could not be changed because we needed to follow the whole procedure, and not even the chief executive could change it. Chairman, I don't know whether you recall that. No, I'm not familiar with that. You are. So the administration at the time said that it had followed the whole procedure and consultation before the draft was prepared, and the only step the administration could take was to publish it in the Gazette. So if the administration could not alter it, neither the legislature could. And at the time, we all voted against it. The administration at the time, that for the purpose of salvaging its relationship with the legislature, there was no follow-up on this. But, well, anyway, I raise this question here, and perhaps the administration could ask the DOJ on 342 and 343. On section 143, on the notice published in the Gazette and the procedure, what is the relationship with the legislature? anyway for LegCo to veto it. Yes, next time give us a paper to respond to this. Chairman, next time we'll respond to Ms. Ho's comment. And I want to comment that in fact for subsection 15 it states that when we talk about a function, the function can only be specified as a control function unless the FS is satisfied that it is likely to enable the individual to exercise a significance on the business carried on by an authorized insurer. And in fact, the term adopted by the IIS is key function. So it should not be any function, but a key function that is to the satisfaction of the financial secretary. Mr. Chan Kin Po. Well, I think we need not dwell into this on key person in control function. Well, in future, will the new IIA be like what we have now? I hope so. We should follow international standards and practices and must not add any control functions as it likes. I think that the financial secretary will also follow suit. So please maintain the established practice and consult the industry fully before you make any changes. No other questions? Next page 49, 13AF. The authority may impose conditions on granting approval under sections 13A, 13AC, and 13AE. So this is about controller, managing director, and key person in control functions. Subsection 4. The authority may amend, well, in fact, subsection 3. The authority may also impose conditions that it considers appropriate on the approval. Subsection 4 provides that the authority may amend or revoke any conditions imposed. And then, page 50, Mr. Sin Chung Kai. Well, for the notices here, or written notices, does it mean that everything will be notified in writing? Notice in writing. Does it also include electronic means? We will send out letters. So the conventional way, a letter will be sent instead of email. Is that right? Is it Sin? I want to know if these conditions are confidential. Is there a responsibility for the IA to disclose these conditions to the public? Must the conditions be kept secret? Or no such confidentiality requirement? No other questions? Chairman, I have a question. If there is no requirement for the conditions to be confidential, then as a regulatory body, when the authority imposes a condition, will it make public the conditions imposed? If there is no confidentiality requirement, then definitely it will be disclosed. My understanding is that these two are different. If it's confidential, then you must not tell. But if there is a disclosure requirement, then the authority will be required to disclose to the public the conditions imposed. But because there are similar provisions in other legislation, so next time we respond to Mr. Sin's question after we review them. May I remind you, our legal advisor has noticed that in Part 3 of the bill, On serving of the notice, there are other means such as by fax, by email. All these are possible. So it's not necessarily notice in writing to be served.
方法。
That's the method of delivery, Chairman. But then we'll definitely issue a letter. And the letter will be delivered or sent by mail, or there may, and there will also be an email version. So we won't just send out an email message. Because these are very important documents, and so we will state under which section of the ordinance we are making the decision. And I want to say that there will definitely be a letter. Mr. Sin? Chairman, I want to take this opportunity to ask the administration to look at the disclosure issue. Now, concerning the imposing of these conditions, this is not the normal practice. And I think the public do have the right to know. The IIA should make a disclosure on its website, for example. Now, say, for example, certain conditions are imposed. And so the public can then decide whether they are willing to bear certain risks. Yes, Mr. Chen. Now, of course, you need to inform the person concerned. But then as to whether you need to disclose the reasons on your website, for example, then you have to consider whether that will adversely affect the person or the company concerned. Because people may not understand why you are imposing these conditions. And I think these conditions relate to the details. So perhaps you can look at whether disclosure is really necessary. Please consider all these factors and give us a reply next time. All right? So we have different views here on this matter. So please consider members' views and come to a decision. Ms. Sit Ho. Now, in fact, what sort of conditions do you have in mind? Because Mr. Chan is saying that the conditions should relate to the details and may affect and the disclosure of such may affect the person or the insurance company. Chairman, so some may think that we either give approval or refuse to give approval. I can't really think of a scenario at the moment where conditions are required. But then I think this flexibility is required by the IIA. Let's say, for example, what if that person has to be out of town for a while, and so on and so forth. So we need this flexibility. So Ms. Choi can't think of a scenario where these conditions are required. Now, say if you you need to drive, and say if you've reached a certain age, then you may need to have an eye examination or a health check. So you really have to give us some examples. Because according to Mr. Chen Kim-po, you've already consulted the industry. I believe you've told the industry what scenarios you have in mind. But then I was talking about key control persons. Now I believe you do have reasons for having to impose conditions. For example, a person may not qualify initially, but may qualify, say 6 months later. No. I understand that only a fit and proper person can be a director or a key manager of a company, and I think there is a well-established understanding of what a fit and proper person means. Now, because this controller, or rather this person has to be involved, or these persons in control functions have to be responsible for the day-to-day management of the company. Let's say if he is ill, or has to be out of town for a long time every year, then can he still be that? Can he still be the key person in control functions? I think under such scenarios, we may need to put down certain requirements. So the IIA also needs this flexibility. Say, for example, a person may need to go on overseas studies for 6 months. Does it mean that the qualification or the approval has to be revoked? So the IIA needs some flexibility, but of course at the same time there are certain requirements which must be met. I don't think we can really find the best answer today. So perhaps you can consider the scenarios that apply here. Yes, Chairman. Now concerning whether the person is a suitable person, it's for the regulatory body to decide. It doesn't mean that the regulatory body lays down, say, criteria A, B, C, D. In fact, there are a list of factors. For example, his experience, his qualifications, his ability to work out or to carry out his duties fairly, efficiently, and so on and so forth. But then, do we have these provisions? Yes. I can give members one example now. Now we do have a person controlling the intermediaries, and we require this key person to have obtained relevant UK qualifications or to have 25 years of relevant experience. Now a person may have over 30 years of experience in the field, and yet he hasn't got the necessary UK qualification. But then he is already in the process of seeking the qualification, and so the IA can exercise the discretion to give him approval, provided that he can obtain that professional qualification within a specified period of time. All right, I think we can move on. Mr. Sin Chong Kai. Now concerning the conditions, here we're talking about AC and AE, right? 13 AF. So we are specifically referring to AC and AE. Am I right? We're now on 13 AF. And conditions on AC and AE. 13A, 13AC, and 13AE apply to the companies, not the individuals, right? 13AE is about the key persons in control functions. The IA can approve and accredit key persons in control functions. What about 13A? Controllers. 13AE, key persons in control functions. A and AC are about the companies, right? They are about the appointment by the companies. A is about the appointment of the controller. AC is about the appointment of directors. AE is about the appointment of key persons in control functions. So these are all about what sorts of persons the companies appoint. So these conditions apply to the companies or to the individuals. To the individuals. But can the individuals represent the companies? Chairman, I don't quite understand what you mean. Perhaps I'm wrong. I don't know. 13AF says that the IIA may give approval for the persons appointed by the companies under 13A, 13AC, and 13AE. And then the authority may impose conditions. Mr. Sin is correct. The approval is granted to the company. But then if you look at 13AF5, you will see that the notice is served on the company and the individual concerned.
What Mr. Sin said is right. Yes, the conditions will be imposed on the insurer, which appoints an individual as a certain controller or director, and the authority will consider whether that individual is a fit and proper person for the post. And the conditions impose that the insurer should ensure that the person so appointed must fulfill certain criteria. So this is about the insurer appointing an individual, not about the appointment of an individual. That's the same But the authority is not granting approval to an individual, but rather to the insurer, which appoints that individual as a controller or a key person in control functions. All right, clear? But at the outset, that was my understanding. All right, so your understanding is correct. So if my understanding is correct, Chairman, I have a question. We were asking questions about the individual, but in fact, conditions are imposed on the authorized insurer, and the insurer, before appointing an individual, may require the individual to perform certain duties first, but the conditions are imposed on the insurer. Let's say if the individual is not based in Hong Kong for a long term, or maybe out of Hong Kong for a long period of time, then there may be a condition imposed on the insurer. For example, that if the insurer is to appoint that individual as a controller of an authorized insurer, then the insurer should ensure that the individual will be in Hong Kong for a certain number of days. That's one example. Chairman, we had different views, but never mind about that. I think the conditions should be imposed on the insurer. For the insured or the policyholder, they might want to know more about the company itself. So if there are conditions attached, should the insured be notified of the conditions as well? I believe there will be provisions on this. Now, I think on the point made by the DS, we'll go back and think about it and reply in writing. Our existing practice is that all information relating to the insurer is confidential. We do not disclose such information because we also need to consider that it is a financial institution. So there may be sensitive information not suitable to be disclosed to the public, and we'll go back and think about it. All right, next page then. 13AG on page 50, which is procedural requirements for rejecting application or imposing or amending conditions. In 13A, 13A, C, A, F, and AE, if the application for the approval of the appointment of an individual, of a controller or managing director or key person in control functions is rejected, before rejecting such application, the authority should give an opportunity for the individual or the insurer to make representations. Next, page 51, 13AH. Offense to provide false information in connection with application for approval. A person commits an offense if the person, in connection with an application for the approval under section 13A, AC, or AE, makes a statement that is false or misleading in a material particular and knows that or is reckless as to whether the statement is false or misleading in a material particular. Subsection 2. A person commits an offense if the person, in connection with an application for the approval under section 13A, AC, and AE, omits a material particular from a statement with the result that the statement is rendered false or misleading, and knows that or is reckless as to whether the material particular is omitted from the statement. A person who commits the above set offences is liable to a fine at level 5 and to imprisonment for 6 months. Next, 13b to 13b on page 57. Relates to approval of persons proposing to become certain controllers of the authorized insurer. They have 15% or more of the voting power. And it is stipulated that such persons should be approved by the authority, or that there may be restrictions or the insurer may be penalized. So we are making some drafting amendments. So, for example, the insurance authority will be changed to authority. And again, for the appeal, it will be lodged with the Insurance Appeals Tribunal instead of with the Financial Secretary. If there are no questions, then page 58. 14. About notification of change in particulars. The authority should be notified, and the authority has the power to object to the change. And our amendment here is about addition of key persons in control functions. As mentioned just now, approval is required. So any change in particulars or change in individual must be made known to the authority. And also, the time frame is set to be within a month after the date on which the change takes place. And following that, we have a number of technical amendments. On page 59, on the left-hand side, there is a deletion. That is about appeal to the Financial Secretary. And as mentioned before, this will be dealt with by the IAT. Next, page 60 is a new section. 14 capital A is about determination of fit and proper, and the matters that the authority must have regard to in determining whether a person is fit and proper. And let me explain once again that for A, the authority should have regard to the education or other qualifications or the experience of the person. B, the person's ability to act competently, honestly, and fairly. C, reputation, character, reliability, and integrity of the person. D, the person's financial status and solvency. And E, whether any disciplinary action has been taken against the person by the Monetary Authority, the Securities and Futures Commission, the Mandatory Provident Fund Schemes Authority, or any other authority or regulatory organization, whether in Hong Kong or elsewhere, which in the authority's opinion performs a function similar to those of the authority. If the person is a company in a group of companies, any information in the possession of the authority, whether provided by the person or not, relating to A, any other company in the group of companies, and any substantial shareholder or officer of the person of any company. G, the state of affairs of any other business which the person carries on or proposes to carry on. No questions? Let's move on. Next, page 61 on the appointment of auditor and actuary. Section 15 of the ICO stipulates that a qualified auditor or an actuarius should be appointed, and our amendment is that the appointment of the actuary should be approved by the authority for an authorized insurer incorporated in Hong Kong. Chairman, coming back to 14A, apart from satisfying the conditions for being a board director, the person so appointed should also meet the requirements here. So this is the set of criteria on top of the criteria for becoming appointed as a company director. Page 62. Still on appointment of an actuary, for the newly added 3A to B, it includes procedure for seeking approval of an appointment of an actuary. And then the authority can, by serving notice on the authorized insurer, revoke the approval of the appointment of person as an actuary if the person is not or no longer a fit and proper person. And then there is a provision on written representations. And then next page 63, 15AA, the authority may impose conditions on granting approval under Section 16 in relation to the appointment of an actuary. Mr. Chan Kin Po. Well, it's said that it should be a qualified actuary or an actuary with the prescribed qualifications, but now we don't have an institute of actuary. Will you assist in setting up such an institute in Hong Kong? We're now discussing with the relevant institute or association. There is a history to why it's drafted in such a manner. We do not have a subject of actuary in Hong Kong in the past. Any approval given would be based on the person being a member of the relevant institute of actuary overseas. Now the situation has changed, and we are still discussing with the relevant institute, and at present we only specified why or how this person could be qualified for appointment as an actuary. And in future, on discussion, if we can reach a consensus on how to make a change to this section, we will. On appointment of an actuary or appointment of key persons, will there be a window period? Say, if this person has committed to something so serious that the appointment should be revoked or immediately, and this person should cease to be a key person of this company, then if no one else can be appointed immediately, do you have any procedure to deal with this window period? Procedure for window period. First of all, will there be a window period?
For all these appointments, whether we are talking about actuaries or key persons in control functions, we'll give them preliminary notice to the effect that we'll exercise our authority to terminate the approval from a certain date. So these persons can prepare their defense in anticipation of the of our decision. So there will be time for them to make such arrangements. So in other words, there won't be a window period. So sufficient notice will be given for them to prepare their defense or to take appropriate action. Yes, basically that's going to be the case, Chairman. But if a window period really arises, we will look at the actual situation and see whether the window period is acceptable. Please don't be overly optimistic. Please don't think that there won't be a window period. No, in fact, that was a case of collective fraud in a leading U.S. accountancy firm, and then we also had the Lehman Brothers incident. And so maybe in some cases you will really need to immediately resign the appointment. Now, because sometimes the offense is committed by only one person in the company, and the person is really a key person in control functions. Then I think if a company is in such a situation, it has to, as soon as practicable, make an appointment and seek the IA's approval. Because you're talking about 30 days, and so that person may do something not on the first day but on the 30th day. Even if there is a window period, if the duration is short, then such a situation may arise. But then Ms. Ho is telling you that there is a real possibility of a window period arising. Mr. Chen Kin-po, I want to say that an insurance company, in fact, is a company of a large scale. There are, I think, about a dozen actuaries, and there are a number of deputy CEOs, and there are also succession plans. And I want to say that a company will not stop running because of one person. And of course, there are deputies to the to any person. And in an extreme case, the insurance company will be willing to pay a huge sum to poach another person. But of course, in the most extreme situation, then the company will have to cease operation. So in fact, there are really many ways to deal with such a situation. And the IIA has the ultimate trump card. So the company will have to use all possible means to put someone back in the driving seat. Right, I think we can continue.
就係去到第64版，咁
Page 64, 15A. and B. When the actuary or the auditor is replaced or removed. And then, in fact, we've kept the provisions. We've just amended the terms. And 15C now. Standards to be complied with by an actuary. So these are standards to be that the authority finds acceptable. And then 16. An authorized insurer has to keep proper books of account. And then under the triangle, we have subsection 5. The authority may, by serving a notice in writing or an authorized insurer, require the insurer to provide to the authority within a period specified in a notice any books of account that are required to be kept by the section and are required by the authority for performing its functions. And then 6, an authorized insurer served with the notice which without reasonable excuse fails to comply with it commits an offense and is liable to a fine at level 5. And I want to know whether the books of account include the electronic records. All forms of books of account, Chairman, including the electronic books of account. And then page 67, 17, up to section 21 on page 71, they're about financial information to be submitted to the IIA, periodic actuarial investigation of insurer with long-term business, statements of transactions of prescribed class or description. So these are the updates of the terms. Section 20, the duration to be shortened from 6 to 4 months. Is it that the industry has been consulted? Mr. Chen Kin-po? I haven't received any negative comment. This is reasonable. In fact, because this is a very complicated bill, there is a task group to study the bill in detail, and no negative comments have been expressed. All right, we can always go back to the previous sections if members so wish. Next one. Page 72, section 22. Sections 22 and 23 are about classes G and H, businesses relating to retirement plans. There is a requirement for separate accounts to be kept. This is a protection for policy holders. We need to ensure that there is separation of assets and liabilities attributable to long-term business, because in the case of liquidation, we do not want these assets to be used to meet the liabilities. So members can refer to pages 72 and 73. All right. I think it's about time. We're now on page 73 and we'll start from page 74 next time.
嗱，我哋進入其他事項。
AOB now. Our next meeting will be held on the 27th of January, Tuesday, 10:45 a.m. And then there will be another meeting on the 9th of February, a Monday at 2:30 p.m. Depending on the progress, I need to schedule extra meetings. In fact, the progress so far has been quite good. All right. So the meeting is adjourned. Thank you very much.